Alright. On merits, my lord, it is the case of the state government, my lord, that for deficit stamp duty payment, my lord, the collector has passed the order annexure P12 of the writ petition, page 62, by which a sum of rupees 3,24,000 rupees was observed to be less paid while mortgaging certain plots by the respondent, my lord. Now, that order has been subsequently affirmed by the Board of Revenue, and the challenge to the order passed by the collector, Katni, as well as the Board of Revenue was made before this Honorable Court by filing the writ petition. Now, the writ court, my lord, has appreciated the various provisions as enumerated under the 1990 Act, 1998 Act, and has observed, my lord, that since the collector has wrongly interpreted the provisions in these circumstances, my lord, the impugned orders were quashed and a cost of rupees 50,000 was also imposed upon the collector for wrongly interpreting the orders. Now, the challenge has been made on two folds before your lordships, my lord. First is that the interpretation which is being imported in 1998 with the Stamp Act, my lord, has not been properly appreciated, my lord. We have brought in appeal, my lord, that Rule 12 has been interpreted, my lord. Although if Rule 12 and Rule 13 of 1998 Act of Registration Act may be seen, my lord, vis-a-vis the Stamp Act, my lord, then it can be easily inferred that the plots which has been mortgaged and for which the registry has been sought, they are costing an amount of rupees 9 crores. So, if because the Act itself says, my lord, that if at all the plots which are being mortgaged to the municipal corporation, which is reserved for EWS category, my lord, 125% value is to be taken. If the builder is not completing the internal project development project work within a period of 3 years, this is the import of Section 12 and Section 13. So, my lord, the property or the plots which are being mortgaged, my lord, the rules, although we have quoted in our writ appeal, my lord, if the quoted portions are to be seen, my lord, then it is my lord, ground number C and internal page 10, my lord, Rule D is the main part, my lord, which has also been interpreted by the writ court, my lord. This says, my lord, that before proceeding the issue, it is imperatively to formalize the terms as given in 1998 rules, which are important, my lord. Rule 12. Permission for development work of a colony on receipt of an application under Rule 8, subject to provisions mentioned in Rule 9, 10 and 11, after fulfilling the various conditions, the permission for development of the colony, Form 5, shall be given by the competent authority in order to ensure the complete internal work in the colony out of the plot or house or flats, as the case may be, to be developed by the colonizer, leaving the plots or the houses or the flats reserved for economic weaker sections and the lower income group, the plots or the house or the flats in following opposite to say that the mortgage of the colonizer would be concerned by the municipality first. The interpretation of this bold portion is there, my lord. In case of a plotted development, such a number of plots, the cost of which under the prevailing collector guidelines rate for that area for plotting development, excluding the cost of the construction on such plot, if any, is equal to 125% of the cost of the internal development. The cost of the plot है 125%. Now, Section 13 may be seen, madam. This is the next page, madam. Period of completion of internal development work of the colony. 13.2 says, madam. 13.1 says, madam, that it has 3 years to complete the work. If within a stipulated period of sub-rule 1, any colonizer does not complete the internal development work of a colony, then the competent authority, after giving a reasonable opportunity to be heard to the colonizer, shall take up the internal development work of the colony and shall get the development work completed on an execution of such work, or the expenditure incurred thereon shall be recouped from selling of 25% of the plots mortgage under clause 1 of Rule 12. So the plot value is 125%. Now, if the mortgage is being done to these plots with the municipal corporation company, and for that the mortgage deed is to be executed. Then the stamp duty is to be charged on the total value of the plot or the commodity which is being under mortgage with the authority. This is the contention which we are raising before your lordship, my lord. But the honorable Red Court, while interpreting, क्योंकि जो प्लॉट्स जो मॉर्गेज हो रहे हैं वो 125% कॉस्ट के हिसाब से मॉर्गेज हो रहा है, क्योंकि वो 3 साल में नहीं कर पाया और उसको सेल करना पड़ा, तो 3 साल का तब लगेगी ना, तब लगेगी, लेकिन जो उसकी वैल्यू है बेसिकली वो रूल्स ही बोल रहे हैं कि वो 125%। सर ये सिचुएशन आई नहीं, लेकिन एट द टाइम ऑफ स्टैंपिंग of the mortgage deed, since the lower stamp duty has been paid, it is paid in terms of 100%. And when the objections were raised, the authorities has observed that it has to be paid from 125%. The builder has also deposited that requisite amount also. So this has also been considered by the collector while dealing with the case, that since he has already deposited the amount by quoting 125%, in these circumstances, he has observed, that in terms of Rule 12, the 125% stamp duty is required to be paid by the builder. Now, this is a proceeding in which the interpretation is being made by the collector, If at all, it is being erroneous also, then for that, he cannot be charged with a cost of rupees 50,000 from his personal pocket, If at all there is an erroneous interpretation also, then also, in the last part of the order, we kindly appreciate, the Honorable Court has observed, that the petitioner is also entitled for the cost of the litigation, which is the gross misunderstanding of the legal provision on the part of the respondent authority, which is quantified to be 50,000. This cost may be recovered from the concerned district.
This development, such number of cost of this under the prevailing guidelines for that area of project development, including the cost of construction of the रेट तो आपको उसी से एडजस्ट करना पड़ेगा, प्रिवेलिंग कलेक्टर रेट उसमें माइनस करना पड़ेगा कंस्ट्रक्शन।
हाँ, कंस्ट्रक्शन का तो हम ले भी नहीं रहे।
125 भी कैसे देते हैं?
कलेक्टर गाइडलाइंस पे जो प्लॉट्स की वैल्यू है,
उसका सर मैं कॉस्ट ऑफ कंस्ट्रक्शन को उन्होंने इक्वल किया था।
हाँ, कंस्ट्रक्शन के बिना जो प्लॉट्स की वैल्यू है उसको 120 सर एक बार और मैं
इक्वल टू 125% of the cost of internal development. प्लॉट की वैल्यू होगी 125%।
नहीं, प्लॉट की वैल्यू नहीं था, जो मॉर्गेज कर रहे हैं उसको
वैल्यूएशन 125% थोड़ी लोगे। प्लॉट की वैल्यू तो कलेक्टर गाइडलाइन से निकालते हैं।
हाँ, प्लॉट की वैल्यू तो कलेक्टर गाइडलाइन,
प्लॉट आपको एक्सक्लूड करनी वो 125% निकालें।
In case of plotted development, such number of plots, the cost of which under the prevailing collector guidelines say for that area for plotting development, excluding the cost of the construction on such plots, if any, is equal to 125% of the cost of the internal development. So, apart from the interpretation of this level,
properly क्या कहना चाहता है
सर? What the authorities in the state of Madhya Pradesh has interpreted to this provision is that the plot, 15% plots are